I want to talk about this with retired California Superior Court Judge Ladoris Cordell. Judge, thank you for being here. We don't know what issues Anthony's attorneys will raise on appeal, but the absence of a black person in the jury is likely to be one of the main issues. The defense raised it during trial. A judge rejected the challenge to have those jurors struck. How would an appellate court weigh whether excluding all the black jurors is a basis for appeal?
As you said, the lawyers on both sides stated that this case was not about race, but look at their actions. When the defense objected to the exclusion of black potential jurors, leaving no African Americans on the jury, that was the second round of challenges. The district attorney insisted he dismissed them because he didn't want educators seated because the incident took place at a school-related function involving high school-age minors. That is ridiculous. You know, it's like saying a real estate developer is on trial. We can't have anyone on the jury who owns any real estate. That's just ridiculous. The judge determined the dismissals were race neutral. And basically, I see this, and I think the defense saw this as a blatant use of peremptory strikes as a pretext, a way to exclude black jurors. And it's not uncommon for prosecutors to exclude black people from juries where there is a black defendant. The Supreme Court has weighed on this twice. In 1986, in the Batson case, where Thurgood Marshall himself said, and I'm quoting, ending racial discrimination in jury selection can be accomplished only by eliminating peremptory challenges entirely. And then in 2020, the Supreme Court, with Kavanaugh writing an amazing opinion, said basically, you cannot use peremptory challenges as a pretext to get rid of a certain type of people. I think this is a very strong case for reversal on an appeal because of this.
And it could go back again to a trial if that is the case. I mean,
Yes.
then there was the jury instructions, another aspect I think will likely be raised. I mean, jurors were allowed to consider the lesser charge of manslaughter in addition to murder as well. I mean, ultimately they chose murder. Will the fact that the judge gave the jurors the choice between the two be something that the appellate court will look at closely?
I think, first of all, that the judge was correct in saying the prosecutor charged murder. Murder in Texas is the intention to kill. So the judge said, I'm going to add manslaughter because the evidence in the case supported a finding of manslaughter. And what is manslaughter? It is the unintentional killing of someone. So there were sufficient facts to support that. So I don't think that's really going to be the issue. The issue is why this jury chose to believe this young man intentionally killed, and also the question of sentencing. He's 17. I understand a stellar academic record in high school, and just 17 years old, no history of criminal activity. Why 35 years?
So the jury in Texas does that,
definitely
though, right?
Going to come up.
Excuse me, Judge. The jury in Texas does that. Does the judge have any discretion to change that in Texas?
Yeah, in Texas, the sentencing recommendation comes there, and the judge, I believe, could do something if the judge wanted to increase it or even decrease it. So there are issues on appeal. I think the strongest one is going to be on the exclusion of African Americans from the jury. You know, it isn't the rule that because you are a certain race that you have to have somebody of that race on the jury.
Right.
But when you have the conduct here, where there were three, I believe there were black women, educators, and the prosecutor just decided, well, we can't have educators because they're probably going to be biased and it's too close to them being in high school. That makes no sense at all. So I think that is a very strong issue on appeal.
Judge Ladoris Cordell, thank you.
Thank you.